My name is Lori Lawson, and on behalf of the League of Women Voters of Skagit County, I would like to welcome you to this candidate forum. I will serve as the moderator. The League of Women Voters is a nonpartisan organization. We do not support or oppose any candidates. We encourage the informed and active participation of all citizens in our government. Membership is open to women and men of all ages, and we invite you to join us. We acknowledge the candidates this evening for joining us, and we appreciate those of you who view this. We hope you will learn more about these people who wish to represent us. Each candidate will be invited to make both an introductory and a concluding statement that will be 2 minutes long. Community submitted questions have been provided to the candidates. Each candidate will have 1.5 minutes to respond. Time may prevent asking all of our questions, but we will begin with these candidates for the office of Superior Court Judge, Position 3. The Superior Court handles cases related to felony criminal issues, civil, dissolution and custody, juvenile, paternity and adoption, probation, and mental commitment proceedings. The 3 candidates who will appear on our ballot for this race are here this evening, and I'll introduce them in alphabetical order. And then would each candidate please raise your hand so when I call your name so the audience can see who's who. Elizabeth Yost Neidzwowski. Thank you. Heather Shand Perkins. And Tom Segwang. Thank you. Our timer will be tracking the time, which begins with a green screen as it counts down and turns yellow when 15 seconds remain. When it turns red, the time is up, so please stop talking. We ask that candidates be respectful of the time allowed. If you speak beyond the time limit, your microphone will be muted. We will begin with the 2-minute introductory statements from each candidate. Elizabeth Yost Neidzwowski, please unmute your mic and begin with your statement.
Hello, my name is Elizabeth Yost Neidzwowski, and I am a Senior Deputy Defender at the Skagit County Public Defender's Office. I supervise our juvenile office, and I'm also a trial attorney in our adult felony unit. Our juvenile office does a couple of different things. Of course, we represent juveniles who are facing criminal charges in Superior Court, but we also represent parents who are faced with losing their children due to the state. And we also represent individuals who are being held and detained against their wishes due to a mental health crisis. Before I came to this job, I grew up in Anacortes. I graduated from Anacortes High School and Western Washington University. I moved to Virginia for law school and graduated from Washington and Lee University School of Law with honors. And after school, I worked at a large civil litigation firm in Southern California. I represented businesses and professional organizations in civil litigation. I handled contract disputes and professional malpractice claims and various other financial issues. I ultimately left that firm, though, and became a criminal defense attorney, and I've been doing that ever since. And the reason for the switch relates back to an experience that I had in law school. When I was in school, I worked in my school's capital defense clinic, where we represented people who were on death row. I had some amazing experiences, including working on an appeal to the United States Supreme Court. But most of my time was on one particular case. I worked on that client's final appeals, and they were denied. I went to ask the governor for clemency, and that was denied. And in the end, there was nothing left to do but sit with my client on death row for his final day. So I did. And that experience changed my life. It showed me how powerful the law is, and it showed me how important it is that those exercising this power be diligent and extremely careful in its use. If elected, I will be careful, I will be diligent, and most importantly, I will be fair, always. Thank you.
Thank you. Heather Shand Perkins, please unmute your mic and begin your statement.
Thank you. My name is Heather Shand Perkins, and I'm running for the position of Skagit County Superior Court Judge. I currently serve as the Court Commissioner in Skagit County Superior Court. I was appointed to that position by the current judges, Judges Brian Stiles, Judge Laura Okome, Judge David Severin, and Judge Dave Needy. After a nearly 20-year career in private practice, I decided to consider serving as a judicial officer. I started this process in 2017 when I started serving as a pro tem commissioner in Superior Court and a pro tem district court judge. As the current court commissioner, I'm the only candidate who's hearing cases as a judicial officer, I have the experience needed to serve as your next Superior Court judge. I am from a family who has dedicated their lives to public service, whether it be in the military or law enforcement. My father served for 30 years with the Washington State Patrol, 10 years with the Skagit County Sheriff's Office, and continues to serve on the hospital board here in Skagit County. I was raised in Skagit County, was excited to return here after college and law school. My goal has always been to come back and serve our community. Upon moving back in 2005, I immediately joined service groups and organizations in our community, and I truly believe in service above self and am committed to the residents and citizens of Skagit County. As a commissioner, I strive to work in partnership with local government, law enforcement, attorneys, and community organizations to ensure our legal system is able to address the issues facing our community on a daily basis. Thank you.
Thank you. Tom Segwang, please unmute your mic and begin your opening statement.
Good evening, everyone. My name is Tom Segwang. Surely, in your decision about who you are looking for as a candidate best prepared to fill all the duties of the Superior Court judge, a person who has seen it all in the justice system and in Superior Court, handling all kinds of cases from both sides over time, including criminal cases, civil cases, family law, juvenile offender cases, injury cases, and trust and estate cases. It's from this broad experience that a person accumulates the knowledge and wisdom necessary to exercise good judgment. I'm very prepared to do this. I have over 30 years of experience in our Skagit County legal system. I have over 30 years of experience handling criminal cases, which represent 60 to 70% of the caseload in Skagit County. One half of that time was spent in prosecution, including a stint as your elected Skagit County prosecutor. For the last 13 years, I've worked in part as a criminal defense attorney, among other things, representing indigent defendants in Superior Court. This has included some of the most destitute and forgotten people in our community. And I've seen in that role how desperate people can get and how they fall into the plight of despair and homelessness. I have represented people who have sued other people, and I've represented people who have been sued. I have been an appellate attorney, handling over 50 appellate cases going right up to the Washington Supreme Court. I have successfully litigated cases in federal court, and I have successfully run a law office in Skagit County since 2007. So I'm a small business person as well. On a personal note, for those of you who want to know a little bit about me, I'm 59. I have 4th or 6th kids. I've been married to my wife for 20 years. We live in Bow. We have 2 children and wonderful grandchildren. It's this type of a background that will allow me to have the judgment which is needed to be an effective Supreme.
Thank you. In this next section of the forum, we will move to the responses to questions which have been prepared by the league members and provided to the candidates ahead of time. Each candidate will be asked to respond to the same question as they are called upon. So for the first question, as a reminder, you will have 1.5 minutes for these replies. Question number 1. What is the most important characteristic a judge can have and why? Candidate Segwang, please unmute your mic and respond to this question.
Well, the question asks generally what a person needs to be an effective judge. In this case, it's a Superior Court judge. And the Superior Court is the court of general jurisdiction in the state of Washington. So all types of cases kind of come through there as a general proposition. It is important for a person to have experience with all those types of cases, and I have that. Similarly, the person who fills that position should have a broad experience in terms of who they represent on both the defense and the plaintiff side, or in terms of people who are charged with crimes, or if they're plaintiffs or defendants. I have that experience. Third, it should be someone who has the right background in terms of knowing how to resolve cases effectively. Those are all important things that are needed. But the question asks, what is the most important thing? And for that, I make reference to something called the Code of Judicial Conduct, which is in Washington. And in that, there is reference to something called the Appearance of Fairness Doctrine. And I'm simply going to suggest to all of you listening tonight that at the end of the day is the most important thing for a judge to have if they're serving. The idea that they do not take sides, that they are impartial. And it says that in all matters, personal, business, whatever, a judge has to act with complete appropriateness as to whatever issue is in front of them. And
thank you. Next, candidate Zwiski. No, close. I'm sorry. Please unmute your mic and respond to this question.
Thank you. It's Elizabeth Yost Nedzweski. A judge must be courageous. Our Superior Court judges decide issues that touch at the very heart of our families and our community. Judges resolve child custody disputes, business disputes that threaten our livelihood, criminal matters where people could be locked up in prison for years and years, housing issues, foreclosures where people could be evicted and lose their home. The list goes on. And a judge's job is always to follow the law, even if it isn't easy, even if it's going to make some people mad at you or upset. And in fact, with the nature of our judicial system, the adversarial process, there very likely will be somebody upset if a judge is making a ruling in a case. I have 2 kids, they're ages 5 and 2, and my husband and I have been talking to them a lot lately about treating other people fairly. We've started to talk about how it hasn't always been the case that everyone was treated the same, and that it's our job to make sure that we treat everyone fair. My son, of course, the child of 2 lawyers, started asking questions almost immediately. What do I do if someone isn't nice to my friend? What if I do if there's a bully? And the answer that we've told him is that you speak up. You speak up about what's right and wrong, and you tell that person if they're not doing the right thing. And judges have to speak up and do what's right also, even if it's not popular. They have to follow the law, and that takes courage. Thank you.
Thank you. And now, Heather Shad Perkins, please.
Thank you. The most important characteristic for a judge should be the diversity of experience. My experience serving as a judicial officer and experience with community service attest to the importance of this critical characteristic. An effective judge is someone who is well prepared, has extensive knowledge of the law, and has the capacity and willingness to conduct each proceeding in a fair and objective manner. Judicial officers must balance the use of compassion and understanding for each litigant before them, and ensure each litigant leaves the courthouse with the hope that their lives and their families can address the current issue and achieve the ultimate goal of moving forward. They need to leave knowing that the judicial officer listened to them and gave them their day in court. Regardless of the outcome, most often of which one litigant or the other is not pleased with, and sometimes both. The judicial officer must ensure the litigants know that they were heard and listened in a respectful manner, which is what I do on a daily basis as your current court commissioner. Thank you.
Thank you. Question number 2. What changes do you see as top priorities to improve the effectiveness of the judicial system? And we will start with candidate Heather Shand Perkins.
Our judicial system needs to advance to be more open and accessible to working people, single parents, people of color, immigrants, people who are disabled, and non-native English speakers. The formality of the court system can be intimidating, and legal terms are confusing to some and those who do not work with attorneys. I see my position as the court commissioner as one who works in partnership with local government, law enforcement, attorneys, and community organizations to ensure the legal system is advancing with the issues facing our citizens, to address the issues of courthouse hours, availability of legal services for non-represented parties, virtual appearances for those working in the working population, and to lessen the formality of the legal terms used to allow all litigants to understand the process. As the current court commissioner in Skagit County Superior Court, I preside over the self-represented domestic motions calendar dedicated to those who cannot afford an attorney. These litigants often face economic hardship when entering the courthouse before they even enter the doors by being forced to miss work. As the court commissioner, I have worked to maintain court operations during the COVID-19 pandemic, implementing video court to address emergency cases at inception, and expanding operations with video court as time passes. We need to continue with these procedures to expand the court for all of us who want to be served.
Thank you. Okay, and then on to candidate Segwang.
Thank you. I agree with a lot of what Heather said here. The question was a little bit vague here, and I answered it from a little bit of a different perspective. There are a lot of technical things that go on and that have been going on inside the courthouse, which I think can be improved to make the general experience inside the courthouse more effective in terms of the way cases are managed and in terms of the cost that is imposed on litigants when they get involved in court. One of the things that's already happening through the clerk's office is the filing of documents electronically. Skagit County is on the path to doing that. They're probably about 50% of the way through, but they haven't quite reached that point completely. The COVID situation is actually helping that quite a bit, ironically, because the court has had to resort to those types of things. The second thing that I would improve, I think, in terms of it's sort of related, is the filing of judicial copies. What folks don't realize is that when we file papers, oftentimes we have to file a separate set of copies with the Superior Court Administrator's Office so the judges have paper to look at. And I think that's kind of an antiquated practice. I think that's something that should change, and they should start taking copies electronically like the rest of the world and move into the 21st century. The third thing that I've actually proposed to the Superior Court is something that's done in San Juan County, it's done in federal court, it's done in the Court of Appeals, and that is the service of documents electronically. Service is a little bit of a different thing. So those are three things I think where there could be improvement.
Thank you. And Elizabeth Yost Nedwowski.
Thank you. When I hear the word effective, I think about how well is our judicial system serving our community. And one of the biggest struggles our community faces, like most communities, is mental health and access to treatment for people struggling with mental health issues. Skagit County used to have a mental health court. It allowed people with serious mental illness to get treatment and support within the community instead of going to prison. Such support would include medication management, counseling, support finding a job and accessing benefits, as well as help getting back into school. We don't have a mental health court anymore, and that is not a good thing for our community. We see the way that mental health touches so many of our loved ones and how often it can lead to homelessness and criminal charges. As a criminal defense attorney and as someone who has previously spent quite a bit of time representing people who are being detained for mental health commitments, I've seen clients do a shuffle from arrest to the hospital for a fit for jail, to the jail, and then back to the street without ever really having the support they need to succeed. And I've worked closely with several mentally ill clients who have been held at the jail for nuisance type charges and seen the further deterioration that occurs when they're held, sometimes in isolation to keep them safe from others. We can do better than that as a community. Mental health court is one of the ways that we can do better. Instead of cycling people in and out of our jail, in and out of prison, and then releasing them without support, reestablishing a mental health court would be a way to set them up for success and to better serve our community. So that is a change that we could make to improve the effectiveness of our court.
We will return to you in just a moment with this next question, so hold on. Question number 3. The court, in its mission statement, mentions treating participants professionally, impartially, and respectfully. Our community includes people of color, a variety of cultures, and members of the LGBTQ community. What training or understanding of respect do you bring to this role? Elizabeth Yost.
Thank you. I'm really glad to see a question about this because it's really an important issue. In my role as a criminal defense attorney, I work with people of all cultures, races, and genders. As part of my ongoing training, I've done extensive work on understanding and furthering equity within the justice system and understanding the racial bias that forms the history of our country. In 2017, I applied for and was accepted into a year-long fellowship program called Just Lead, sponsored by the Washington State Bar Association and the Access to Justice community, which was focused on growing leaders to work towards equity and justice within low-income and marginalized communities throughout the state. I brought that training and work back to my local office in the way of through ongoing training of our attorneys and resource sharing. I've also used that training in my work as a board member for Northwest Justice Project, or NJP. NJP is our state's largest civil legal aid provider. We have over 200 advocates in 18 offices around the state. I've been on its board of directors for about 5.5 years. When I was chair of our board development committee, we adopted a statewide race, equity, and justice initiative, REGI, for both the entire organization and also for our board as individuals, committing to continuing to learn about and work towards equity within our community. Since then, I have brought my training back to our county and worked with the attorneys in our office and leading trainings for the attorneys in our office. Thank you.
Did you call me?
No, I'm so sorry. I didn't see the mute. Heather Shand Perkins, please. Question number 3.
Thank you. As the current court commissioner, I have attended a variety of trainings and courses, including Judicial College, which specifically addresses the issues facing not only the LGBTQ community, but also those who see bias every day in our community. The Washington State Supreme Court created the Gender and Justice Commission with a mission to actively address gender and bias in the courts. This has been in place since 1994 and continuously works to identify concerns and make recommendations to the courts regarding the treatment of all parties, attorneys, and court employees in the state courts. I have presided over court cases as the court commissioner and handled cases of private attorney involving all members of the community. Members of all communities need to be recognized and respected for who they are as individuals and addressing them as their identity and applying the law, most importantly, fairly to all. Acknowledging them for who they are and what they bring and the experiences they have been through so that they can feel that they have been heard, respected, and receive justice. In our community, as a volunteer lawyer program steering committee member, past president of the Skagit County Bar Association, and member of Skagit Rotary, I have strived to educate myself and others around me about societal and economic issues facing our community members. Thank you.
Thank you. Tom Segwang.
So what I've done is over 30 years, I've participated in many, many cases involving many people who fit into the categories that are described there. As a prosecutor, I prosecuted people for racial and religiously motivated crimes. I have, in private practice, I represented an African-American couple who filed a wrongful termination lawsuit in federal court in Seattle. So I got to understand firsthand how they felt about how they were being treated unfairly because of the color of their skin. More recently, I have represented an 8-year-old Hispanic boy and his mother whose father was killed in a wrongful death case in Skagit County. I worked with her, who does not speak Spanish, to try to make sure, English, excuse me, who needed to not only learn about the justice system from that perspective, but also I faced a series of immigration consequences, which I assisted her with. As the prosecuting attorney for Skagit County and also in Whatcom County, I worked to make create a workplace which represented the community. Among other things, I have put out campaign pieces, which you will see as an example, which are bilingual. So I am very aware of these issues and working very hard to.
Thank you, Tom. Question number 4. What have you seen as the most effective forms of treatment for deterring juveniles from further criminal acts as juveniles or as adults? Candidate Segwang.
Okay, my answer to this question goes back to my own childhood. When I was in 2nd or 3rd grade, there was an incident that I was involved with. It was very simple. I was inside of a classroom and I took a baseball and I threw it across the room and it landed in an aquarium. And because of that, the principal of the school, I went to a Catholic school, pulled me out in the hallway and she looked at me. She knew my whole family and she said to me, Tommy, and that's what she called me. She said, Tommy, I know that you're a really good boy. And she told me that 3 or 4 times in the hallway, just her and me. And I looked back at her and I said, yes, I am a good boy. I'm a very good boy. And then she said, I know that was a mistake that you made. And I said, yes, that was a mistake that I made. And then she said, I know that you will never do that again, anything like that, because you didn't mean to do that. And I said, you're absolutely right. That was a mistake. So to me, I remember that story now when I'm about to turn 60, because she demonstrated to me that she had faith in me as a young person in a number of ways. Number one, that I understood that I did something wrong. She was very positive in the way that she approached me and made me feel, and disciplined me in a way which was, I think, very sensitive. And the juvenile justice system, I've worked on juvenile cases for, 25, 30 years now. And I think that's what needs to happen there. That is what happens, I think, generally speaking. And what we need to do is take these kids who are in these bad positions and make them feel like they're important in the community.
Thank you. And we move to Elizabeth Yost Nydwowski. I'm saying it different every time. I'm so sorry.
Thank you.
Thank you.
So I represent both adults and juveniles facing criminal charges in Skagit County Superior Court. And quite frankly, I'm concerned about the revolving door that we're seeing in juvenile court. There's a few kids coming back in and out of court over and over and over again. And those same kids in adult court once they turn 18. And as a parent, I'm concerned about some of the serious crimes we're seeing from young people in this community. I've had kids recently come to me begging for intervention and support and mental health treatment specifically. And I've been really surprised at how difficult it is to connect them with resources and get them out of detention into a more therapeutic and supportive environment. My biggest concern is that when we lock young people up and sanction them repeatedly with time in detention or jail, they become even further disconnected from their community. And they start to see themselves in a certain light that isn't healthy for them or for the community. But I've also seen the way that with early support and access to resources, it can make a huge difference in their lives. We have some wonderful programs in this community, but we need to continue to support them as a community. Diversion is one powerful tool to accomplish this, connecting kids with resources before they ever make it into the formal justice system, either in the courthouse or the detention. And I'm really glad that we are having this conversation, and I hope that it's one that continues to spread throughout our community, because these solutions are always going to be a lot more effective if they are community-based and supportive rather than court-imposed. Thank you.
Thank you. Heather Shand Perkins.
Thank you. I am deeply passionate about societal pressures and inequalities as they relate to children, which began in my studies in society and justice at the University of Washington. The youth are our future, and helping them break the cycle of not only violence, but pure injustice and inequality that they face is the grassroots approach to see change. I believe in instilling hope in not only the youth I see in the community service groups I serve in, but also instilling hope in the parents I see on the dependency and domestic motion calendars. In my role as court commissioner now, I speak to individuals before me in an individual and personal way, trying to take an interest in their lives to help develop a strategy to overcome the barriers they face in their daily lives. Speaking to them about the adverse childhood experiences that they have suffered and acknowledging this trauma that they have endured not of their own choice, but by actions of those they love dearly. Studies have shown the higher the adverse childhood experience the children have, the higher likelihood the youth will be truant from school, involved in at-risk youth court programs, or before the court in a criminal fashion as a youth or an adult. Identifying the acute childhood experiences earlier in their lives and providing services to the youth prior to their involvement in the court system and their family has shown effective and positive results. And that is when intervention needs to occur via our community organizations. Thank you.
Thank you. Question number 5. At times, litigants and or their lawyers get angry and agitated. What experience or training have you had in de-escalating conflict? Heather Shand Perkins.
Thank you. As the current court commissioner, I'm frequently involved in any number of issues that take place in a very, very emotional way in my court between the plaintiff and the defendant, or a mother and a father, or the state and a family. Much of the work I've done for the last 20 years in private practice was dealing with family law and civil matters. I continue to deal with very emotional proceedings now. One of the lessons I learned early on in my career in private practice, and it's a lesson I carry with me to this day in court every day that I preside over cases, is the need for us as judicial officers to ensure that the parties leaving our courtroom know that they have been heard. These parties simply want to tell their story, and they want to know that it was considered fairly and equitably. As a judicial officer, I work hard to ensure each person who comes before me feels that their testimony is not only heard, but understood. Litigants deserve to see that the judge is an individual who genuinely takes an interest in them as people, individuals. I adamantly believe that a judge must remain calm throughout the proceedings and, if required, redirect the parties to the precise issues before the court, always in a way that brings compassion and civility to the courtroom. Thank you.
Yes, please, candidate Segwang.
I hate to keep talking about being an old man and having 30 years of legal experience, but I am that person. And over those 30 years, I have literally handled thousands and thousands of cases in both the realm of criminal law and the realm of civil law. And on that road, I have run into, it seems like, every type of personality one could ever imagine in terms of litigation. Some who are docile, some who are extremely aggressive. And when I say that, I'm talking about not just the litigants, I'm talking about the attorneys. And so I've had an extremely large amount of hands-on experience managing those types of situations. And I guess I feel like I have employed every trick in the book to try to make sure that when there are disputes boiling in the courtroom or outside the courtroom, when you're on a telephone with another attorney, that everybody learns that civility is extremely important, and it's very important to take a step back. It means oftentimes not saying what's in your mind and just thinking about things. It happened to me just the other day in a case, and that's, I think, where the real important experience is, and that's what I'll continue to use as a Superior Court judge.
Thank you. Elizabeth Yost Nedwaski.
I would agree completely that it's not unusual for litigants or even lawyers, unfortunately, to get angry and agitated in court. And the reason being, of course, that the matters that we touch upon in Superior Court are extremely important and serious, and they go to the core of people's lives. As for the lawyers, I think it's particularly important in Skagit County to maintain that civility. That's because it's a really small legal community, and most of the lawyers have repeat interactions with each other. Lawyers as a professional group need to treat each other and the court with respect at all times. I've gone through de-escalation training on multiple occasions as part of my training for work. But from my experience, what works the best is common sense. If you treat people with respect as human beings, they're going to get a lot less worked up and de-escalate more quickly. When people come to court, it's important that they feel heard and that they have a chance to express their side of the story. And I will be the first to agree that sometimes court calendars are very long. They often last for hours or all day. And sometimes there's a big push to move things along. And it's important for a judge not to let that happen. It's important for a judge to give everybody their chance to be heard. Otherwise, they'll leave court and they will not feel like they've been treated fairly. They will not feel like they've had their day in court. But if the judge takes the time to listen and treat them with dignity and allows them that moment to feel heard, even if they don't agree with the ultimate ruling, they're going to walk away feeling better than if they were just.
Thank you. Question number 6. Please describe your experience with mediation steps as part of the local judicial system. Candidate Elizabeth Yost.
Thank you. And just to clarify, it's Elizabeth Yost Nedzweski. Mediation is when you try to resolve your differences outside of court with a trained professional to guide your discussions and decision-making. When I worked in private practice as a civil lawyer, I participated in numerous extensive mediations in complicated business matters involving large dollar value cases. And my clients really benefited from mediation because it allowed them to have a preview of our arguments in the case, as well as the weaknesses of their case, without the risk and expense of a jury trial. A strong mediator, in my experience, can be invaluable in helping to settle a dispute in a fair compromise. Now, in my mind, mediation should continue to play an important and perhaps an even enhanced role in our courts because it's more cost-effective and usually less time-consuming than a trial. It frees up the courtroom for things that cannot be mediated and saves the litigants time and money. This is going to be particularly important moving forward as the courts start to get back to normal operations after the limitations of coronavirus. For the past few months, there have been extreme limits on the types of hearings that take place in Superior Court and no jury trials. Moving forward, there's going to be a backlog of cases waiting to go to trial that need to be addressed. Any cases that can be resolved via mediation will create more room in the courts for those other cases to be addressed. Increased access to mediation could be a way to alleviate some of the backlog pressure on the courts, as well as increasing access to justice for those who litigation may be unduly cost prohibitive.
Thank you. Heather Shand Perkins.
Thank you. As a private practicing attorney for nearly 20 years, I mediated hundreds of cases and resolved a large percentage of them by working to create a resolution that each party could accept. Mediations are a highly effective tool to avoid the expense and divisiveness of trials, especially in family, domestic, and civil matters that are financially burdensome on our community members. It allows the parties to reach a resolution that can repair relationships rather than further destroy them. Litigation is expensive for the majority of those who are involved in cases before the court. Many people cannot afford an attorney, which creates a financial barrier preventing them from seeking justice. Mediation is a less expensive route to case resolution that would not otherwise be available, and it creates a bridge of togetherness rather than divisiveness that sometimes a court can bring. Thank you.
Thank you. How can a judge make sure that his or her own personal biases are not affecting a decision?
I think you skipped me.
No, I'm coming to you with this question. You're going to be first.
But I didn't answer the prior one.
No? Yeah, you're right. I'm terribly sorry. I was on to question number 6. Let's go back. Candidate Segwang, please answer mediation steps in our local judicial system, please.
Very good. My most memorable experience with mediation is when I married my wife. That sounds kind of funny, but it was over 20 years ago. She had 2 children from a prior marriage who were teenagers when we decided to get married. And I decided that having a mediation between the 3 of us was probably a good idea because we were going to be spending a whole bunch of time together. And what was funny about that is that everybody was surprised about it, including the mediator when we got in there. But the idea was that there was going to be a situation where there was going to be some conflict probably, because when people live together, there's conflict. And so we went in and we had this thing, and it's all worked out well because I got 4 grandkids now and that sort of thing, and everybody's pretty happy, but we laugh about it now. But the truth is we got some things on the table, and that's what mediation is about. So that's my first real big example. Going beyond that, I'm probably the only attorney in Skagit County who's ever had an official mediation of a criminal case. That was in 2001 when I was prosecuting the Frontier Ford embezzlement case, which was the biggest financial fraud case in the history of Skagit County, which eventually went to a jury trial. The attorneys on the other side wanted me to give them a misdemeanor for a $1 million loss, and I said I wasn't going to do that. But Judge Meyer wanted us to do that, and we did it. So we tried. Beyond that, I have been involved in all sorts of mediations over time in private practice in all kinds of cases, personal injury, trust and estates disputes, commercial things. It's a very valuable tool. I have a lot of experience with it, and it's something that I will continue to try to use as a judicial officer going forward.
Thank you. Now we'll go to the next question. How can a judge make sure that his or her own personal biases are not affecting a decision? Right back to you, candidate Segwang.
Okay. So the answer to that question is another loaded question. I don't think that you can really get rid of your biases. That's what a bias is about. So the best that we can do is try to use techniques to make sure that, particularly as a judge, you're not allowing those things to influence you too much. The other thing about a bias is it isn't always necessarily a bad thing. So it's a word that's sort of thrown back and forth, but I think we do have to keep perspective of it. But I think when it's used in this context, what people are talking about is bias in a bad way, prejudice, if you will. And so as a judge, I think you need, first of all, as Heather Perkins said earlier, you need to listen. That's very important. Listen very carefully to the parties, the narrative that they're giving to you, and try to figure out whether there's something peculiar about that case relating back to you that would cause you to somehow put this bias in place. So that's one thing you can do. The second thing is, I think you have to honestly determine what your biases are in any given situation. And that in and of itself can be difficult. But for example, for me, I'm a 59-year-old guy who has been very privileged in my life. And if someone shows up that is not like me, I might tend to be biased against them some way. I have to think about that. The third thing, I'm running out of time here a little bit, is in Superior Court, you can talk to the other judges and get their perspective on cases. It goes on all the time in appellate cases, and it can go on at the Superior Court level.
Ready to move on to Elizabeth Yost Nedwetsky.
Thank you. I almost answered unbiased for the earlier question about the most important characteristic a judge should have, because it is. In order for our citizens and our community to have faith in our courts to do the right thing and follow the law, our judges must make decisions in an unbiased manner. And the only way for a judge to be sure that their personal biases are not impacting their decisions is to be aware of those personal biases, because we all have them. We all have our own biases, whether they be related to our upbringing and experiences, or simply to living in this world and being exposed over and over again to some of the systemic biases of our society. And it takes work and personal study to make sure that we are aware of our own biases. In some of the anti-bias trainings that I've completed for my work and through the Just Lead Fellowship, we started with an implicit bias test, which is a short test just to bring out your own biases that you may have. Once you're aware of your biases, then you can do research and reading and self-reflection on what those biases are and why you have them. As a criminal defense attorney, I've worked really hard to be aware of my own biases. For instance, I often ask myself, do I connect a little more naturally to the female client who looks and talks like me with shared life experiences? Maybe she's a mother and has young children. Maybe we grew up near each other. Maybe we went to the same school. I want to make sure that I'm advocating just as hard for every single client as I am for that one client that I had the natural connection with due to our shared background. That is one of the ways that you can overcome the biases that you may have. Thinking about them, reflecting on your own biases, and just being aware of them. And I don't think the timer was going for that.
Thank you. And our timer will be set on the next one. And thank you for being aware of that. That was great. All right, we're going to move on to Heather Shand Perkins on this question, please.
Thank you. I am so proud to be a member of the Washington State judicial system led by our Supreme Court, who openly issued a letter to the legal community on June 4th of 2020, encouraging the discussion of bias openly so that we can work together to ensure that we all do better. As both the candidates just mentioned, the best way to address your bias is to be present in yourself, to know you have bias. As the Supreme Court stated, we cannot undo the wrong that has been done in our society, and we must recognize the role that the judicial system has played in devaluing the lives of those before them, including Black lives. The justices of the court called on all of us to recognize the role we have played, recognize the ability to do better, both individually and collectively, to develop a greater awareness of both conscious and unconscious bias. I work with my current judicial officers individually and collectively every day to recognize our biases and improve the access to justice. A judge needs to be aware of implicit bias and systemic racism within themselves and within the judicial system in order to work towards a change. Reaching the right decision is not always the popular decision, and it takes courage. We must lead our colleagues on the bench, our judicial staff, and members of our community in the ongoing discussion of bias, access to justice, and maintain presence in ourselves to always recognize when we have a bias to overcome it.
Thank you. We will move to question number 8. There have been complaints from victims, family members, defendants, and the general community about how long acts of processing Superior Court claims take from filing to conclusion. From the background. What do you see as the main reason why that process takes so long? What do you see as potential viable solutions for shortening that process? We will start with candidate Heather Shand Perkins.
Thank you. I completely agree with the conclusions made in this question, especially as we're coming out of this COVID coronavirus pandemic and the delays that are now being seen in the court system. Ultimately, a judge is responsible to ensure the proper administration of justice. The sound administration of justice is in the hands of the court to uphold, protect, and develop methods and procedures that will ensure the process is fair to all litigants. The National Center for State Courts has conducted studies of courts in Washington to identify and address the issues causing unnecessary delays. Our court must follow the guidelines and adapt them to our current Superior Court administration. Procedures and processes must be put into place to streamline the cases. In Skagit County Superior Court, we must implement case scheduling orders that set definitive timelines for cases. The addition of more judicial assistance that can help judges manage the case scheduling orders must be addressed immediately. The hard reality of what we're faced coming out of this global pandemic is that all of our judicial officers and administrative staff must work to monitor case progress and stop the unnecessary delays by ensuring that the schedules are met. And one of those ways that we can do that is by having the judicial rotation that we've begun this last year and maintain that so that there aren't cases where delays and continuances are requested simply because a different judge is hearing the case. That is very ineffective.
Thank you. Yes. Candidate Segwang.
So I have practiced in, 5-6 counties in north of Seattle over the years. I've also practiced in federal court. Other courts do it differently, and Heather Shand has picked on a couple of those things. If you go to federal court and you file a case in federal court, within days you get communications from the court setting forth a very specific schedule about how the case is going to be managed over time. Included in that are timelines for depositions, for discovery, and also, in many cases, for mandatory mediation early on. The reason why cases take so long after they're filed is because people don't talk about them unless there's something completely urgent on. So the court imposed schedule in that situation. The lawyers don't like it, the parties don't like it, but it forces everyone to the table. Skagit County has no such rule. They have never had it. King County has it. I filed a case in King County about 3 or 4 months ago. You get an email back immediately that gives you this information and directs you as to how the case is going to be managed. It's the Wild West up here in Skagit County, and we need a little bit of that formality coming to Skagit, because the lawyers in Skagit County like to delay the cases for this, that, and the other reason. The other part of that is on the criminal side. It's a little bit different because we have a backlog of cases, a shortage of funds, a shortage of attorneys to represent the indigent people, and the prosecutors keep filing cases that some of which shouldn't be filed.
Thank you. Elizabeth Yost, Nedwedski.
Thank you. The question is right. Superior Court cases do take a long time. It's not unusual for felony cases and civil cases to take well over a year to resolve. And I agree with most of the ideas that the other two candidates have discussed. But I think it's also important to point out that the reason many of these cases take so long to resolve is because they're complicated and important rights are at stake. Criminal defendants have a due process right to have an attorney that's prepared, and that takes time. A lot of cases, civil cases, criminal cases alike, have lots of discovery, complex legal motions that are heard, and witnesses to coordinate. But that doesn't mean there aren't things we can do to speed things up and limit some of the unnecessary delay. For example, one thing that really drags out a criminal case is when a criminal defendant misses court and gets a bench warrant. When the warrant is issued, trial dates are canceled and speedy trial is reset until the person is arrested on the warrant and booked into jail. This takes a lot of time and money. I've been working within our office to start using a software to combat this problem. Basically, we're going to be using a computer program that allows us to send an automatic text message reminder alert to clients about their upcoming court dates. Studies have shown that defendants often miss court because they're living in poverty, homeless, and worried about survival, and court takes a back seat. Studies have also shown that a text message reminder is a cost-effective way to get people to court, avoid warrants, save money on arresting people on those warrants, and finally, to speed up the court process. So that's just one additional way that we've been working on.
Thank you. Okay, we are to question number 9. And it is a long question, and I'm just going to read it straightforwardly, and we'll start with candidate Elizabeth Yost Nedwedski on this question. And I can read it again in a moment. Okay. We have seen examples of community members living in poverty who owe thousands of dollars in court fines. These same people struggle to overcome barriers to employment and treatment due in part to this debt. Some seek out the treatment that they need, and while in residential treatment, their fines and interest and collection fees increase. For some, their inability to pay these fines reduces their chance of being able to obtain a driver's license, a vehicle, a job, or decent housing. The longer they are unable to pay, the more the interest fees add up and often get turned over to aggressive collection agencies. Do you have any ideas about ways that fines could be paid off or consequences rendered in a reasonable way that does not create more barriers to employment, more punishment inequity for those unable to pay their fines quickly? So there's the question.
Thank you. Just to be clear, legal financial obligations, as referred to in the court and in this question, are referring to court costs and fines. Those are different than restitution, which is money owed to crime victims who have lost property or goods or money as a result of a crime. Restitution is non-waivable. But when I first started working as a criminal defense attorney, I was struck by exactly the spiraling LFO situation, which is described in this question. I saw firsthand how it impacted my clients' ability to get their driver's license. And in a rural county like Skagit County, a driver's license is almost essential to any type of working situation. That's why I joined the board of Northwest Justice Project. NJP has been at the forefront of some really important litigation that has resulted in limits on the types and amounts of court fines that can be imposed on indigent people. Our courts, locally included, have also been working hard to assist. by forming a relicensing clinic, which helps people pull their legal financial obligations from collections. But the process is cumbersome. I've worked on it for countless clients, and it involves filing quite a few motions. And if you have fines in courts that aren't a part of the relicensing program, then sometimes you aren't able to benefit and get your license back. So depending on where your fines are located, you may not benefit. What we need to do is make the fine remittance programs universal. If you meet state definitions of indigency, your fines should automatically be pulled from collections and courts. You should be able to set up a reasonable payment plan. It also needs to apply to older cases that aren't.
Thank you. Okay. Heather Shan Perkins, please.
Thank you. As a judicial officer, I treat each litigant on an individual basis. Before any form of restitution or discretionary fines are instituted, as Elizabeth just stated, restitution is non-waivable, but there are discretionary legal financial obligations that the court must work closely with the defendant and counsel to ensure the payment of the fines does not have a crippling effect on that particular defendant's ability to meet their financial responsibilities. In 2015, the Washington State Supreme Court issued a ruling in State versus Blazina that held a court must consider a criminal defendant's current and future ability to pay legal financial obligations prior to setting those fees and fines. A judge must consider waiving discretionary fines and fees for an indigent person, a person who cannot afford to pay them. Legal financial obligations can have crippling effects on the defendant for years, just as the question stated, creating financial barriers. Moving forward, the courts should consider and explore community service as an alternative to legal financial obligations and entertain conversion, modifications, and waiver petitions. Skagit County needs to embrace and adopt a model close to what has already been instituted in Kitsap and Pierce counties called Reconsideration Day, where the court spends an entire day and the judges hear hundreds of cases that would not otherwise be heard to address the legal financial obligations.
Thank you. And candidate Segwang.
Okay, here's the deal. This is a trick question. The Superior Court in criminal cases does not impose fines. I've been practicing in Superior Court for close to 30 years, doing criminal cases all the way down the line. I have recently, in representing criminal defendants, I have asked prosecutors to consider imposing fines as opposed to sending them off to jail somewhere. And the prosecutors uniformly don't want to do that. This is an issue that occurs in municipal courts and in district courts around Skagit County. So the only way the Supreme Court becomes involved in this is if there is an appeal from a court of limited jurisdiction to Superior Court, because that's the first line of appeal from one of those courts. I am the person who handled a case called State versus Smith in about 2001 or 2 in Whatcom County when I was serving as Assistant Chief Criminal Deputy that dealt with exactly this issue. I went to the Washington Supreme Court on one of these issues, and what Ms. Shan just said here, that part of the law was actually used in that case, that people should not have to pay fines if they can't afford them. The court has to go through constitutionally an analysis of whether they have the ability to pay. I believe in fine forgiveness for people who are making good faith efforts to try to resolve these things. I also am in favor of creating a special appellate process in Superior Court to address these types of problems.
Thank you. Thank you all. We have reached the time for you to make your concluding statements. You will each have 2 minutes for your statement, and we will start with you, candidate Segwang.
Am I on? I'm on, yes, okay. I am asking the voters to consider me as their next Superior Court judge after making an objective analysis of what it takes to be a Superior Court judge. I mentioned earlier that it's a court of general jurisdiction where the judge is required to try to exercise good judgment. We use that word and we throw it around a lot, but it's a very important word. The question is, for a Superior Court judge, how does one acquire judgment, good judgment? And I think that everyone here would agree, because everyone here is talking about experience, that experience in and of itself is important, an ingredient of whether someone is able to serve effectively in that position. So that's one part of it. The second part is this position requires someone who has broad experience in all the things that occur in Skagit County Superior Court, as well as any other Superior Court. And I have, as I have said, and I'm trying to repeat here because I do think it's important to have experience in all those cases, and over time, I have it. Very broadly in criminal law, I've been 60 to 70% of the case law or the cases in Superior Court are criminal. I've been practicing criminal law for 30 years. I've been practicing civil law for 15 years, more or less. And I've handled all sorts of cases, representing all sorts of people. I've resolved all kinds of cases. And I can talk about the subcategories. I can talk about juvenile cases. I can talk about family law cases, commercial disputes, personal injuries. I've written wills for people. All of the things that come to the Superior Court, I have experience in. And I'm asking the courts, the voters to simply objectively analyze that. And at the end of that process, I would hope that you would find that I have those credentials and that you would choose to vote for me. Thank you very much for the chance to talk tonight.
Thank you. And next, I just lost my place. I'm sorry. Elizabeth Yost, Nedweski.
Thank you. And thank you all very much for taking the time to listen to this panel discussion and learn about the candidates for Skagit County Superior Court Judge. I hope you'll also take the time to vote in this primary election because judicial elections matter. Judges make decisions about some extremely important issues in our community and about the lives of those who live here. And I'm running for judge because I care about this community. It's where I grew up. It's where my husband and I chose to raise our 2 young children. Our oldest will be starting kindergarten in the fall, and we want our kids to have a safe place to grow. One of the issues that I care deeply about and that I've spent my career advocating for is increased access to justice for our entire community. I've seen the struggles that many of our neighbors have faced and have to work through, whether that be mental health issues, addiction, housing instability, job loss, especially lately due to coronavirus and racial bias. I have seen how all of these issues make it harder for people to access our courts and receive justice. And I've seen how not all children have the same opportunities that my children have to learn and to grow safely. That is why I joined the board of Northwest Justice Project, to increase access to justice and fairness in our courts and in our community. And that's why I'm running for judge. When I first moved back from working in Seattle and Southern California, I spent about a year working as a law clerk for the 4 Superior Court judges in Skagit County. And it was one of the most interesting and fulfilling years of my life. During that year, I read every single brief or motion that was filed in the court, and I learned about every single type of law. And that was when I first started to think that I wanted to be a judge. If I'm running for judge, if elected, I will be fair and impartial. I will listen. I will always follow the law. And most of all, every day, I will try my hardest to be courageous and do what is just. If you have any questions or would like to connect, please don't hesitate to reach out. My website is www.elizabethforjudge.com. Thank you.
Thank you. Heather Shand Perkins, please.
Thank you. I am running for Superior Court Judge because I truly believe my experience and commitment will enable me to serve with distinction as your next Superior Court Judge. Litigants deserve to see the judge as someone that they can relate to, someone who genuinely takes an interest in them as an individual and works with them to create a pathway of hope in their lives. The integrity of our court and the trust of our community places in our judicial system is extremely important to me. My experience, knowledge, compassion, and commitment to Skagit County have prepared me well to serve as your next Superior Court Judge. I see my role as a judicial officer as a leader in our legal community, one who works in partnership with local government, law enforcement, attorneys, and community organizations to ensure the legal system is advancing with the issues who face our community. As a single mother, it's important to me to be a role model to my teenage daughter and expose her to be a servant to her community. I have dedicated much of my personal and professional life to serving families in Skagit County during some of the most stressful times of their lives. Children and their successful development are my passion and have been my passion since I moved back here in 2005. When you look at my service to the community and my experience, you will see that I truly am the best qualified candidate to serve as your next Superior Court judge. As a final thought, I just want to thank the League of Women Voters for putting on this forum in this fashion. During the coronavirus, we weren't sure that we would be able to speak to the citizens in this fashion. So I appreciate the leadership that they have shown in moving to this Zoom platform and allowing us to educate the voters. So thank you very much.
Thank you all very much for being here. This concludes our discussion. We want to acknowledge the City of Mount Vernon, TV 10, TV 26, and especially Candy Galindo and her team for recording and with all the technical assistance. We invite you to learn more about these candidates. Look them up at Vote 411 website, where participate candidates can place information for your convenience. Go to their websites and social media pages. You can find us at our website at SkagitLWV.org, or find us on Facebook. We're the League of Women Voters of Skagit County. All people are welcome to be members of the League of Women Voters. We will repost the links to this forum on municipal and community pages. Feel free to send the links to other people. It's important to note that ballots will be mailed July 15th, 2020. Please remember to sign your ballot and put it in a mailbox, or better yet, a ballot box, before 8 o'clock on August 4th, 2020. If you have to use the mail, the postmark is critical. Please allow extra time for that mail to go to be processed and come all the way back to Skagit County. It is suggested that you mail it before July 27th, or once again, in a ballot box right here in Skagit. Thank you for taking your time to view our broadcast, and please vote and encourage others to do so also. Thank you all.